Good morning, everyone. Welcome to this session, Managing U.S. Litigation Risk, Essentials for Korean Companies Doing Business in or with the U.S. My name is Helen Kim. I'm an attorney at my own law practice, HKH Law LLC, based in Atlanta, Georgia. I handle employment and business law matters for business clients, including Korean-owned businesses and companies, mostly based in Georgia. I'm so happy to be here. I've decided after our planning talk that I would serve as a moderator to allow Chairman Hendricks and the rest to speak more freely. Let me go ahead and begin first by introducing our panelists. I want to first introduce at the far end Samantha Ritter Park, who's a corporate attorney and chief legal counsel in the Americas for LG Chem America, Inc. Prior to joining LG Chem, Samantha worked at international law firms including King & Spalding and Baird Home LLP, where she represented public and private companies in M&A and other corporate matters. To her left is Jin-Hee Kim, attorney at law and head of global dispute resolution practice at Chi-Pyong LLC. She specializes in cross-border dispute resolution, international arbitration, and antitrust litigation. She began her legal career at international law firms including LaBeouf, Lamb, Green, and McRae, and also worked in-house for LG Display's sole headquarters, overseeing global litigation before joining Chi-Pyong. Next to me is Glenn Paul Hendricks, who's the chairman of Arnow, Golden, Gregory LLP, an Analog 200 law firm located in Atlanta, with offices in Atlanta and Washington, D.C. Glenn handles complex cross-border business disputes, including international arbitration and litigation. He serves as a private sector advisor to the U.S. State Department on international litigation issues, including serving as a U.S. diplomatic, including serving on a U.S. diplomatic delegation to a special commission of the Hague Convention on Private International Law. He is also active in the ABA, having served as the chair to the ABA International Law section and as the ABA's representative to the U.S. State Department's Advisory Committee on International Law, which brings together leading international law professors and practitioners to advise the State Department on significant international law issues. Okay, so all of the panelists here were curious before we began, by show of hands, how many here serve as in-house counsel for a company? Okay. All right, a couple. How many are US-based attorneys? Oh, okay. How many are Korean-based attorneys? Okay, so more US than Korean-based. All right. And for those that are US-based, how many have a significant Korean, represent a significant number of Korean clients? Okay. Well, it sounds like the people that didn't raise your hands probably want more, right? So this panel should be very helpful. Okay, let's get right into it. Again, we're talking about mitigating, really, we say managing, is really mitigating U.S. litigation risk, right? People want to have business, do business in the U.S., but it's very complicated on compliance issues. The last thing a company wants to expose themselves to a very costly and time-consuming, lawsuit in the U.S. So how do we go about that? Let's start first to talk about the distinct features of litigation, the U.S. litigation system versus Korea. And Jin-Hee, you can practice both in the U.S. and Korea. So why don't you start off by telling us what are some distinct features of U.S. litigation in comparison to litigation in Korea?
Thank you, Helen. Can I speak without the mic? Is this room small enough? And so that we don't have to maybe speak around. Okay. And if I'm not speaking loud enough, or is this better? This is much better? Okay. Thank you for the very flattering introduction. I'm quite honored and flattered to be sitting here. The question, distinctive features of U.S. litigation and Korean litigation. It's such a broad question and a very interesting one. So I'm going to preface by saying, if I sound like I'm overgeneralizing, please forgive me. I don't intend to do it. I'm only guided by my own experience and limited by my perceptions as well. So I don't mean to say something that sounds like a sweeping statement about Korean law and U.S. law. I know too little to be doing that, and we have better lengthy textbooks explaining the differences. Having said that, I do want to share some of my experiences with you and also get from you your experiences, because that's how I think we advise us and teach ourselves about how to manage cross-border litigation for a variety of our clients. 30% of what I do is U.S. litigation representing Korean clients. The other 30% is international arbitration, primarily in Asia, with SIAC, HKIAC, KCA, and so forth. And another 30% is representing clients cross-border. So foreign clients having litigation issues, disputes in Korea, or Korean clients having non-U.S. litigation. And Korean clients are actually very international. A lot of my clients have disputes issues in all continents, cases in Pakistan, Nigeria, Kenya, Hungary, Poland, what have you. And I'm sure, Samantha, you're being a global multinational client, you have litigation issues everywhere. So I want to also preface by saying that Korean clients are actually very savvy in dealing with cross-border litigation. And increasingly so, because Korean companies, they rely on exports and trade. And so more so than my former experience as more of a junior attorney in the US, advising US clients, Korean clients are savvier in dealing with cross-border disputes. Let me say that. So why don't we talk about distinctive features? And I want to say it's not because our client do not know the distinctive features of common law system, jurisdictions, and civil law system. In fact, they are actually savvier when it comes to textbook knowledge, how it's different. They know, although in Korea there's jury trial in criminal cases, that jury trial is different from judge trial, judge-attorney system. They know that there's expansive discovery that is different from mostly allowed in civil law jurisdictions. So why do we then still talk about these distinctive features? And I think it's because it's really for us, because it goes to these distinctive features. They advise and they inform our clients as to what to expect from the judicial system. It informs them about what to expect out of that litigation. And secondly, I think the distinctive features really help either make the attorney-client relationship a successful one or a disastrous one. So I think that's why we still need to address these distinctive features. There's just so many, and I don't want to be overgeneralizing, but let me just say, just give 2 or 3 examples of how they differ and how it impacted, how I think, affected the client's expectations and my relationship with the client. First of all, the importance of testimonial evidence as opposed to documentary evidence. We all know this. We learned from textbook that in civil law jurisdictions, documentary evidence is more important than testimonial evidence. And in the U.S. litigation, you can't introduce any document without a custodian testifying this is an authentic document. So that distinction, how does it affect the litigation risk when you represent a client? And I'm going to make a very practical example here. Korean, you might find that Korean clients do not like to do depositions. Nobody likes to be deposed. I mean, that's a given. But you will find resistance from the client saying, well, we cannot produce this witness, but we cannot travel to where the case is and have our witnesses deposed. We cannot have very high level officers be deposed. And a lot of times, me as being trained as a California lawyer, instinctively ask, well, is there something to hide? Why are you being evasive? And it really goes to, I think, the tradition of your understanding and your acquaintance with the legal system where testimonial evidence is not so valued. For example, in Korea, and this is what I learned after coming to Korea and started taking cases in Korean court, before Korean courts. Parties do not become witnesses. Because when you're a plaintiff and defendant, you will be the first ones to be deposed and definitely to take a stand, less in criminal cases. In Korean courts, parties are not called to testify their case. And my question to my Korean colleague was, why is that? They're the most important clients. And the retort was, why should it be? They have the interest, they have an incentive to lie, they have an incentive to say self-serving statements. And that's the very different approach to valuing testimonial evidence. So party testimonies are you rarely see that in Korean courts. And I experienced that in Hungary system as well. You would expect witnesses to be the parties talking about their emotional grievances. This is an emotional distress case, and yet the party's emotional distress is not heard in testimony. But there's expert testimony. So that's one example. So our clients are not being evasive, are not being difficult in complying with discovery obligations such as depositions. Secondly, why do Korean witnesses not fare too well in depositions? I think it's cultural, and also there's language. For example, if I have witnesses testify and take depositions in Korean, they will do superbly. They will say what they want to say. But then when they're having to express things in English, although they're fluent in English, they say different things. So a lot of the testimony evidence is also restricted by the language and the culture, the training, the familiarity. So we, I think, as counsel, need to be aware of that distinction as we understand how to advise our clients.
And just to interject on that one point, if a foreign client, a non-U.S. client is ever deposed in a U.S. case, no matter how fluent they are, I would typically want to have an interpreter there. Just because there are just so many nuances in your answers and the way questions are phrased. And just as a practical matter, it gives the deponent more time to formulate their answers. And it eats up time. It's usually typically in federal court, there's a 7-hour clock. And so the language issue is real, even for someone who is as fluent, let's say, as Ginny is. I would still want an interpreter.
That would be a challenge. I will say different things in Korean when I'm answering the same question as I will say in English, because I have different ways of thinking going on, and I see it in myself because I consider myself bilingual, who I don't have to have. Another thing I want to throw out as an example is attorney-client privilege. And I'm going to be very careful when I say there's no attorney-client privilege in Korea, because practically there is. And yet you'll see a lot of, what do you call this, Chamber's Guide to Korean Practice. A lot of the articles will tell you there's no such thing as attorney-client privilege. That's shocking, because then you see a lot of news about prosecution raiding attorneys' firms and taking everything out from attorneys' desks and laptops, right? And it is done, but in practice, I don't see that there is no attorney-client privilege. I think it is respected, but the protection is given in a different terminology, and a lot falls under confidentiality, and which means that confidentiality has different scope and different meaning as used in Korea and also in U.S. litigation. So what I want to talk about attorney-client privilege, a lot of the U.S. attorneys that I've worked with, both as in-house and outside, they have the question, why do Korean clients not telling me everything? Why aren't they not forthcoming with information earlier in the litigation? This is something that I should know, and yet they withheld this information until very late. And then you start doubting trust. And you ask, well, why are they being evasive? And I want to throw this idea out. Not that because there's no attorney-client privilege, but because the relationship between client and attorney is also guided by and advised by the legal system that you're working in. I don't want to overgeneralize, but in Korean litigation, attorneys attorneys are advocates still. They're adversarial at times with the opposing counsel, but they don't have that intense where you're advocating the best interest of the client. I see a lot of Korean practice more like you're officers of the court, and you have the judge being more active, right? So attorneys do not really have to be adversarial. Another distinction: attorneys rarely talk to each other. So unlike in U.S., every day is a meet and confer, right? You meet and confer on everything. So one of my Korean clients, I kept using meet and confer, and I thought, why are you meeting and conferring so much? What are you talking? What are you telling the other counsel? So that's where the client is asking, are you telling them something more than you should tell them? Are you telling them more than what I want you to tell? So these are the questions that are not, because they're not arising out of mistrust. They're arising out of not understanding why there's so much meet and confer. In Korean litigation, a case can end without you having to talk to the opposing counsel one-on-one. Because typically there are hearings, we call trials. Unlike trial at the end of the litigation phase, there are trials on a monthly basis or bi-monthly basis, where the judge and the counsel and sometimes the witnesses talk about the case in a more free flow information sharing kind of setting. So the difference. So I'm hogging my time. So those are some of the features that we could consider. I think we as counsel want to be not superficial and don't treat it as our clients not understanding the differences between legal systems, that they don't have a clear understanding of what the strategy should be. But I think it's the more nuanced, how to formulate the right expectations and how to strategize the situation better for your clients who have different legal background, training, and experience. So just want to throw my 2 cents out there.
Thank you so much, Jinhee. So I told you this is going to be a good way to be able to garner and keep great Korean business clients, right? Well, so much of what you said made me think of so many other questions. And I mean, decades ago, I myself was part of the largest international arbitration when I worked at a big, AmLaw international firm, and the client was here in Korea, and the lead partner was, an American man in New York. He felt the same way. He kept asking questions the way typical American lawyers do, like, give me the answer, so I could almost see it. I'm Korean, but I'm both Korean Americans. My Korean kind of sucks, but anyway, I could understand at least some Korean. And you could tell the clients I felt disrespected. I was like, who the heck are you? And then after he would ask them questions, I would hear on my firm side frustration. Why aren't the management being honest with us or forthcoming? And then the management would gripe and I would overhear them, like, these lawyers don't get it. That's what I kept hearing. They don't get it. They're not being, they're not doing their job, et cetera, et cetera. So I have a couple of follow-ups from what Jinhee said. Samantha, as in-house, understanding the differences as well, how do you speak to management? How do you get Korean-based management to understand the necessity of being more open and forthcoming? What are some of the hurdles to kind of guiding them? And then, Glenn, I wanted to ask you that question about interpreters, because I myself have used interpreters for my Korean clients, and sometimes the interpreters are not very good. And so that could actually cause maybe more of an issue than not using one. So I don't know, like, how, you can manage that particular challenge. Well, let me take the mic over to Samantha.
Thank you, and hi everyone. So before I start, I do just want to echo what Jinhee said. A lot of what I'll talk about today is purely based on my own experiences as both outside counsel for U.S. companies and Korean companies, as well as my experience now in-house with a Korean company with expanding operations in the U.S. So to the question that Helen just asked, I think it's a really good one. We have a lot of conversations just internally within our own company about different cultures and different experiences and different customs, different practices. And I think one of the key takeaways that we share internally is that different cultures and different customs are not necessarily good or bad or right or wrong. They're just differences that we have to address and figure out how to bridge the gap between what you can expect being, servicing a client who's in Korea versus what you can expect helping a client in the United States. And, the way that we really do that is by expanding on and understanding what these differences are. Just to give you a couple of examples, we talk a lot internally about, especially as a Korean company doing business in the United States, you have to understand what those differences are. Let me give you just a quick example about at-will employment. I think that there is a very common misconception when dealing with U.S. employees what at-will employment actually means. And I don't think that that's just a common misconception that's specific to Korean clients. I think this is a bit of a global misconception in dealing with U.S. employees. And we've had to really explain a lot about how, the differences are between what protections are offered to U.S. employees versus what protections are offered to, Korean employees in the Korean workplace. And by doing that, we've really helped to understand and really helped to explain to our clients, our internal clients in particular, that you really need to focus on how to understand what at-will employment really means. You'll get a lot of questions, I think, as outside counsel in particular. At-will employment, does that mean that we can terminate someone, for any reason at any time? And the answer is yes and no. Yes and no, you can, but you can terminate an employee at any time for any reason, but not for an unlawful one. And digging into a little bit deeper what those protections are that are afforded to U.S. employees, under anti-discrimination laws and things of the like, which we'll get into a little bit later. But really helping your internal clients to understand what those cultural differences are, what those differences are in the law, to help them make the decisions that they need to be able to make, because they just can't do it without all of the context. And I think that that's really helpful, and one of the things that we, as a legal team, really focus on. I keep looking in this direction. We have some of the members from our HQ legal team here as well, from LG Chem. And we just have the benefit of having a tremendous legal team here in Seoul as well that we can bounce these ideas off of. We can, talk about what those cultural differences are. We can talk about what those differences are in the law and how we can better explain them to our clients.
Yeah, and on the interpreter issue, it really does depend on the witness and the interpreter. And a lot of times what you'll do is you'll have the witness correcting the interpreter, which I think is perfectly fine, because they can express it better than you can. But educating the interpreter ahead of time on some of the key terms they're going to use. I've actually had at least one foreign client that was a repeat player in U.S. litigation. They actually had a trained interpreter specifically who was for legal proceedings. So it's one of those things you got to look at on a case-by-case basis. But I think as a general matter, the interpreter helps, I think, the witness in terms of just having more time to respond. And a lot of times the English is not quite as good as they think it is. A legal interpreter is going to know the legal terms better often than a legal witness will.
Yes. So just to share, how to speak to the management. So having worked for another major multinational affiliate company of where Samantha is currently working at, and having the benefit of working with other large Korean corporations, what I find is that Korean corporations, the decision-making structure is more difficult to understand and fathom than a typical, a U.S. listed company. Each major Korean conglomerate, the conglomerate being Chebar, the large corporations, they have their own culture, own system. A lot of them are similar, but being in-house for 7 years and then coming out, it was this tremendous experience and knowledge I gained from that, having insight into the structure. I think if I want to generalize again, a very big difference in the US when you have a client and the client is giving you instructions and decisions on how to run your case, you trust that person is the decision maker on most of the matters. in Korean companies, decisions are made, I want to say almost on a collective basis. There's not one person who's going to be able to say, yeah, this is how we will do it. They have to escalate, not necessarily because Korean culture is hierarchical, more hierarchical than the US. A lot has been flattened out culturally, but then still within there's collective decision making, such that, oh, I have to run this by somebody and so on and so on. There's also for large Korean companies with large legal teams, such as, for example, Samantha, the client that I work for as in-house had, I think 70 or 80 lawyers, almost like a mid-sized law firm, right? And they are composed of attorneys from different jurisdictions, different bars, and also people who speak English and people who don't. If you have an upper management who don't really understand U.S. litigation, and you have still under the working level counsel who is trained, has a JD from U.S. law school, you will think that that solves the problem, but it really does not. So finding out who your client really is actually more difficult when it comes to Korean corporations, and you have experience with that. I would love to learn from yours as well. Oh, yeah, sure.
No, I think Jim, you just raised a really good point. In particular, one thing that I've noticed is there is more reporting that often goes on in Korean companies than what's typical for a U.S. company. And the reason that that's important goes to some of the issues that we talked about earlier, like attorney-client privilege. One thing that you have to be very cautious about, particularly in working with Korean clients, is helping them understand how you can waive attorney-client privilege incidentally. I think that's so important and something that we focus a lot of time on, because just due to the nature of the reporting structure, information is getting shared more broadly. There are more conversations going on, there are more decision makers involved. And so helping your clients to understand how attorney-client privilege works, when it can be waived, that information can't be shared outside of those who have a strict need to know, is absolutely crucial. And in addition to that, especially if you are dealing with a Korean client who has U.S. operations, you don't want to end up in a situation where you have a higher ranking official from your Korean company, your Korean parent, being drugged into a litigation matter in the United States simply because a report was made to them at some point in time. Or that they offered some comments on a report. We like to try to rely a lot on the Apex doctrine, but obviously if you have someone who's participating actively in that decision-making process, it's very difficult to protect that. So just something to keep in mind.
Yeah, I won't say, which Korean company, but that idea of this is an American affiliate of a Korean-based company, but I've had issues where whatever decision is literally taken up the chain to someone in Korea, and they're not realizing, hey, guess what? If this goes to litigation, every single thing, that all of this decision-making, it could harm you, it could expose you further, and it's very difficult to balance that with the culture of the organization. That's just how the company is run. But that's actually a typical thing I hear of US-based Korean companies. They say, we can't make this decision. We have to keep taking it up, and it's usually to somebody based in Korea. So again, to me, that's an automatic fight to try and exclude the foreign parent. But Glenn, you've had a lot of experience, obviously, in US courts, litigating cross-border disputes. Here's something that I've heard more than just from Korean companies, that foreign companies may not be treated fairly in US courts. So I know that's a big, broad question. Can you address that? And maybe part of what that sentiment is from the perspective of foreign companies is this difference or potential differences in their jurisdiction versus ours. How would you answer that?
It's hard to answer, with broad generalizations, but there's clearly a risk of anti-foreign bias, particularly if you have a case decided by a jury. It's just a reality. But interestingly, the statistics, there have been a few studies on this. The biggest one, unfortunately, is quite old now. It's done in the 90s, but there have been subsequent studies, smaller scale, that generally bear this out, show that when a foreign litigant actually pursues a case all the way to the end, they actually have better win rates than domestic litigants. And statistics on that older study, but like I said, very large over the course of 15 years, showed that foreign parties won 80% of the time where they filed as a plaintiff. You compare that to U.S. plaintiffs, the win rate was only 64%. So 80% win rate for foreign plaintiffs versus 64 for U.S. plaintiffs. If you turn it around where the foreign party was the defendant, the plaintiff win rate fell all the way to 50%. So whether you were a foreign plaintiff or a foreign defendant, statistically you did better. Now, the authors of that study decided that doesn't really mean that there's a pro-foreign bias. What it meant was, in their view, was it's more of a selection bias, that where, you know, that so many of the marginal kind of gray area cases settled precisely because the foreign company was afraid to go to an American jury and what might happen. And so by selection bias, the cases that they felt the strongest about were the ones that went all the way to the end, and they won. And so if you were to take a lesson from that, it probably would be that if you really do feel you've got a good case, whether it's a plaintiff or a defendant, the odds are actually very strong that you can and should win. That said, you know, and we've got Luis Martinez here from the ICDR, and you'll hear on the contracting part of the session, you're better off if you can, at least on B2B contracts, having arbitration provisions specifically so you can avoid a jury. Or if you're not going to do that, you know, have a jury waiver clause, which in some states it's enforceable and others not. Try to avoid a jury one way or another. But if you've got a strong case, you know, don't settle it out just because out of fear that, well, we're not American, the jury's going to be this.
Kind of a follow-up about differences. Are there differences between fees, attorney fee arrangements, no loser pays, that kind of thing? Are there differences that you can speak to?
I guess just speaking to, you know, as a client who is dealing with outside counsel, often both in the United States and in Korea, one thing that I found is, at least in my experience, fixed fee arrangements are more common in Korea than they are in the United States. Particularly many business folks are used to and accustomed to fixed fee arrangements, and so having hourly fee arrangements can be very difficult. At least for many of the Korean companies that we've worked for, budgets are very important. And if you're going to exceed a certain budget, you need pre-approval to do so. So if you are a US-based attorney working with a Korean client, don't be surprised if they ask for a fixed fee arrangement of some sort. It's just much more common and really what Korean clients are more accustomed to.
I want to say, U.S. litigation is so expensive. I'm just period. Korean litigation is so much cheaper compared to U.S. litigation. Distinctions. You will find when you're working with a Korean client, they're reluctant to strategize because they don't really see litigation as a strategic weapon to get what you want. Whereas, you know, you have concepts like race to the courthouse to get the more favorable jurisdiction. I mean, American being litigious, they are really trained and they're well experienced. They would know how to use litigation sometimes to get what you want commercially, right? But Korean companies, I don't want to be, again, overgeneralizing here, but they're very careful to start litigation. And in fact, they're very non-litigious in nature and also in culture. So it will be very hard for me. I thought you had a very great case, but it took almost a year to convince a Korean client to file a suit in New York. One of it, I think, is cost, and also the second thing is about using litigation as a tool to achieve what you want. So, going out there.
Thank you, Jinhee. Jordan Samantha's comment made me think of jurisdiction. You know, obviously we're talking about cross-border disputes. Jurisdiction is where is the right place to file a suit? Or if you are sued, is this the proper jurisdiction? Is the parent company the proper party? Glenn, let's start with you. What are some common jurisdictional issues and actually ways that a foreign company can avoid the jurisdiction of U.S. courts, despite that great statistic, right? That they win if they fight hard enough.
Yeah, that's a really big question. with a lot of nuance. And by the way, there's a very detailed, text-heavy PowerPoint in the materials that goes into some detail on some of the nuances, among other things, of jurisdiction. So I'm not going to cover all of that here, but just a few general points. One is that protecting the foreign parent. Let's say you've got a U.S. subsidiary and you want to protect the foreign parent from either being sued or from discovery. There's just, again, so many factors to consider, but it can be done. I have done it a lot in litigation. A lot of the time, though, it just depends on things the company has or has not done before the lawsuit ever starts. And it goes back to some of the issues we've already talked about. The more control the foreign parent has, the more involvement the foreign parent has over the U.S. subsidiary, the more likely they're going to get drug in. And so optics matter. Just even things as simple as the website. If the website makes it look like it's just one big corporate enterprise, you don't have a distinct U.S. website that has the, very clearly lays out the corporate separateness, you're likely to get drug in. I know LG has separate, like even email extenders. Those kinds of optics, they seem silly, but they're really important. Having not, maybe you can have an overlapping board, but not perhaps complete identity of the board. If you're going to do business in the U.S., just purely exporting to the U.S., there's a line of cases that started with the Supreme Court case in the Castro case, about 10 years old now. Use an independent distributor. That's one way to avoid. If you're going to have sell in the U.S. using websites, there's a whole body of case law about how to do that. How interactive is the website? If it's just a passive website, just here's our product, that's not going to be enough to get you subject to U.S. jurisdiction. But if you've got a highly interactive website where they can take orders and form contracts and things like that, then you are going to be drugged into a U.S. court. So there's just a whole host of factors that, frankly, I just think it's too much to get into here, but that is spelled out in some detail in the materials that you can use to probably not eliminate the risk of a foreign parent or being drugged into a U.S. court, but that you can mitigate that risk, and I think often successfully. I think sometimes there's an assumption, well, the foreign parent is going to be drugged in no matter what. That's not the case. If you do it right, you can keep them out.
Samantha, I want to ask you that same, as a follow-up, avoiding foreign parent liability in a case. How does that play out in an employment litigation case? I mean, you and I both focus on, or I focus on employment. Part of your work focuses on employment. We know lots of federal, U.S. federal workplace laws and anti-discrimination laws where the jurisdiction issues are slightly different. Again, how do you address that? How do you avoid the foreign parent being pulled in?
Thanks. Yeah, so I think that really, or one thing that I want to address on that particular topic really goes back to what I mentioned earlier. I think one of the most important things is pushing down decision-making authority within your organization, particularly if you have separate and distinct organizations, making sure that any material decision-making, particularly when you are in a state where you're acting in anticipation of litigation, that the decision-making is pushed down as far as it possibly can be. And like we talked about earlier, that can be a challenge in any organization, but oftentimes in Korean organizations as well. And when we say pushing down that decision-making authority, that also goes back to the idea that we talked about earlier, that a lot of times, in Korean court systems, we're not accustomed to parties being drugged into matters of fact witnesses. And so what you certainly don't want to have happen, and what we talk about a lot, is ensuring that our corporate officers, particularly corporate officers of a Korean parent, aren't being drugged into a matter as a fact witness in a U.S. litigation matter, particularly in employment litigation. So when we're talking about decisions around employees who are working in the United States, we have to be very careful. And just one thing to note too, as it relates specifically to employment litigation, and Helen can probably talk about this a little bit as well. Keep in mind that if you're a Korean company who is sending expats to a U.S. affiliate, that federal employment laws apply to those expats. So if we're talking about anti-discrimination laws, Title VII, things of that nature, you want to make sure that even though you have some level of control over those expats, maybe coming from your headquarters or from your parent company, that decision-making authority, if it comes back to your parent company, can often result in what we just talked about, which is having a corporate officer, ending up in a U.S. employment litigation matter, which we certainly don't.
And this is probably something the esteemed members in this room already know, but it only takes 15 employees plus for a company, with employees in the U.S. to be subject to federal employment laws. And it doesn't matter. One thing, I represent mostly smaller, like 500 and under, companies with 500 or under employees, but oftentimes with companies that are foreign-owned or immigrant-owned, they're surprised that an employee that's not a U.S. citizen still has all of those rights. Let me ask you, I'm the employment nerd, so Samantha, I gotta ask you another employment question. Beyond employment discrimination, which is my focus, what are some of the issues that you've seen internally with an understanding around wage and hour rights, and maybe OSHA?
So specifically around wage and hour, and also just outside of employment discrimination claims, I think one thing to keep in mind is there are oftentimes within a Korean company, you may see more of a hierarchical structure, particularly as it relates to titles, than what you might see in the United States, maybe a little bit more of a lockstep approach. And in the United States, when you're talking about wage and hour compliance, oftentimes it's very difficult to classify employees when you're thinking through exempt versus non-exempt. If you're applying similar titles to what you might see within your Korean organization, parent company to a U.S. subsidiary, it often, makes it very challenging to properly classify those employees if you're applying the same types of titles that you might be applying, globally on a global scale to U.S. employees. The focus in the United States often when it comes to, job titles and, job duties, you really have to look at what those job duties actually are in order to classify the employees. So one common thing that we see, particularly with Korean clients, is that you may find that people are maybe misclassified as exempt because they hold a title of a manager or an assistant manager, but they're not actually managing any people. So you're looking at the title and saying, yes, this looks like an exempt employee, but actually, in fact, the job duties don't actually involve managing anyone. They don't actually involve having those roles and responsibilities that you would expect to see from an exempt employee. And so that's just one thing that we typically, or at least I typically caution internal clients about, and in my prior life as outside counsel, our clients about in that capacity as well.
One more personnel-related question. Again, this is also based on my experience. When I've dealt with Korean companies, oftentimes, but Samantha, you're bucking that trend, because I don't think you're Korean, although you might be Korean. I'm just assuming. But oftentimes I will go to a Korean company's headquarters and see that all the management are Korean. And as you know, that could, unless you're subject to a treaty or international agreement, subject you to a discrimination claim. Is that something that foreign companies are aware of? How do you break? Because to me, that's a cultural thing too. I mean, if you're Korean based, you're going to feel more comfortable that management is all Korean. So how do you address that, or how is that addressed? And also to you, Jinny.
Yeah, no, that's a great question. And actually this goes back to a little bit of what we talked about earlier. In the United States, employees often, the workforce is not afforded the same protections as you may be afforded in other companies around termination, around end of service benefits, things of that nature. So in my experience, often Korean clients can be particularly surprised by the level of employment-related claims that could potentially come up within your organization when you start growing your U.S. operations. And one of the ways to address that, or one of the things to think about, and that you have to make sure that clients are aware of, is that in the United States, anti-discrimination laws are often relied upon as a means of employees protecting themselves. And not to say that those laws aren't important and necessary and absolutely there for a reason, but there are often times when employees will rely on those laws in bringing claims against companies. And one of the things that we counsel our clients a lot about is how to make sure that you are documenting employment-related decisions very, very carefully. So when we're talking about at-will employment, again, it has to be at-will employment, meaning you can terminate someone for a proper reason and proper purpose as long, or for a reason, any purpose, as long as it's not unlawful. And it's very difficult to prove a negative, right? How do you prove that you didn't discriminate in a case where an employee is bringing a claim against you? And that means documenting the decisions that are made, the proper reasons why those decisions are made. And one thing that we really stress for our clients, to your point, Helen, is that disparate impact is also something that's very crucial that you need to think about if you're doing business in the United States. When we say, you can't necessarily take some action that is potentially discriminatory against a particular national origin, that goes both ways. So if you are, focused on expanding your U.S. operations, you have a lot of Korean employees, you have to be careful that when you're operating in the United States, that there isn't, that perception that a number of your employees, or you're offering favorable treatment to your, Korean applicants in the job application process, for example. And so one thing just to really keep in mind is even a policy or a practice that's neutral on its face could potentially have the impact of causing, disparate impacts resulting in a potential discrimination claim. So a really good example is, let's say that you have job applicants that are applying to a specific role and you put Korean language recommended, preferred, or required. You have to be sure that you carefully document why, with respect to that particular role, the Korean language is required. Is it going to involve a lot of communications with HQ? Is it going to require a lot of communications with the corporate Korean affiliate, the different Korean affiliates, Korean parent? Because if you don't do that, then the possibility exists that there could be a finding that there was a disparate impact if you end up hiring more, Korean employees than potentially employees from another national origin, just because of that policy or that requirement that you put in a job application. So definitely have to be very careful about that.
Okay, keep the mic over there. Hopefully you guys can hear me. Let's go right into a little bit more nitty-gritty into litigation pitfalls, okay? And in our planning calls, we talked about document retention. Earlier, we were talking about too much documents, going up the chain you can expose. But then on the other hand, you're saying document everything. And so this is important. What, again, huge, big question. As outside advisors say to a Korean company, or foreign companies, what would be an appropriate document retention policy that could mitigate some risk in litigation? Or is there a way?
Yeah, I can speak to that briefly, and then I'll give it to my colleagues here who are more involved in the litigation components. But I do think that one thing that's really important to note if you're thinking about document retention policies, particularly with respect to U.S. operations, is that when you are thinking through how a Korean corporation doing business in the United States is dealing with document retention, or thinking through something in anticipation of litigation, you have to remember that U.S. courts are very discovery heavy. You have to remember that things are going to be available. If they're not subject to attorney-client privilege, you're going to have to turn them over. And reminding clients that your emails, all of your emails, if they are not subject to attorney-client privilege, could be discoverable. And so in the event that you're talking through serious issues, you're dealing with in-house counsel, you're talking to outside counsel, you just have to be very, very careful to remind folks that if you put it in an email, it's potentially discoverable. And so having, sound document retention practices that make sure that those emails are being deleted on a regular basis, that the documentation that you're retaining, you're keeping in mind when you're putting it together, particularly when you're in a situation where you're dealing in anticipation of litigation, that you're careful about documenting the appropriate things, and if there are things that are subject to risk, that you're preserving an attorney-client privilege when you're putting together that documentation and getting advice from in-house and outside counsel.
Yeah, and Jim talked about how much more expensive litigation is in the U.S., and it's because of discovery. I mean, there's studies that anywhere from 70 to 80% of the costs of litigation in the U.S. relate back to discovery. And it's the most difficult thing, I think, for non-U.S. companies to comprehend. I mean, they know generally that, yeah, there's this thing in the U.S. called discovery, but just how really truly intrusive it is, especially when it comes to emails. And the way that it can really be exploited by the other side if you have a non-U.S. party, because things like that are more second nature to larger U.S. companies, like preservation holds, document preservation, are less so for a non-U.S. company. And they destroy documents that are not helpful, sometimes intentionally, sometimes unintentionally, after litigation has already commenced. And then you get what's called a spoliation claim, and you can really lose the case, not on the merits, but basically through what's perceived to be discovery abuse. So I think one of the most important things you can do as either a U.S. company or a U.S. attorney representing a non-U.S. client, or as the Korean counterpart, right at the outset of the case, and really even before the case, because the preservation obligation begins even before the case is filed. It's when you have a reasonable anticipation of litigation, not to destroy documents. So if you do have a document retention policy, which is really just a euphemism for a document destruction policy, you need to suspend it for key individuals who are were involved in the dispute, and getting that across, and that document preservation doesn't necessarily just mean, okay, we're going to put a hold on these particular email custodians' box. Do they have notes? It's not just the official corporate documents or file. Do they have things in their office, that they keep? Do they have notes of phone calls and memos and such? They need to keep that, and you need to document it. You need to document that, this litigation hold was put out, periodically reissue it. We have actually software that we use that every few months there's a reminder that goes out to the key custodians, just so that if anyone does destroy documents, well, it wasn't intentional. We've been telling folks we can document, we've been pushing these hold notices out there routinely, because you can end up with a TKO, technical knockout, not on the merits, just because you failed to, honor your discovery obligations. And then also the issue, it goes back kind of related to the jurisdiction issue, to what extent if the foreign subsidiary, the U.S. subsidiary of the foreign company sued in the U.S., let's say you're able to keep the foreign parent out, that doesn't necessarily mean that the foreign company is off the hook when it comes to discovery. Because the way discovery works in the U.S., it's any documents within your custody, possession, or control. And so, the U.S. company, the U.S. sub, doesn't have to have actual physical custody of the documents. If they have control, if they have access to those documents, then you can access them. We litigated a case where it didn't involve Korea, but it was a Russian related dispute, and they were trying to get documents out of the Bahamas. And so they used the Atlanta subsidiary, which had access. They routinely shared documents back and forth with the Bahamas. Completely different entity. There's no piercing the corporate veil, but because they routinely had that access to those documents in the Bahamas, they were able to get them. And so a lot of those issues that we talked about in terms of, corporate separateness and avoiding this notion of control also come into play in the discovery context. And I will say, document retention policy, document destruction policy, a lot of companies that are repeat litigation players in the U.S., they're constantly in litigation, usually as defendants, have very short retention periods. Maybe as short as 3 months on their emails, just because the cost is so exorbitant. If you've got emails going back 10 years, you may have to produce them. But if you don't have them, they've been destroyed, it just reduces the cost. So downsides to that, obviously, in context of conducting business, when you can't find old emails, but there are companies that do that. They have strict, after 3 months, you lose your emails unless you somehow print them out, preserve them, or archive them somehow. You have to suspend that once you get, notice that there may be litigation. But by at least, not having all those emails going back years and years and years can save you a lot of money if you do have an effective retention policy.
In my private practice now, I typically represent more the plaintiff side, so noted document destruction policy, which is an honest way of saying it. Okay, well, obviously, strong document retention policies is one way to mitigate U.S. litigation risk for foreign companies. Let's go to another key way to mitigate risk, which is U.S. style contracts. Chin-hee, let me start with you. How important is it to have U.S. style contracts in place for Korean companies?
So, U.S. style contracts, frankly, we see a lot of convergence in cross-border transactions. I think, for example, LG Chem. I don't know that LG Chem's contracts will not be U.S. style. They are also very Korean style as well. So, I think what you're asking is, what can you put in a contract that might steer your client away from U.S. litigation? I do want to answer that, but having heard all these things, we're thinking we're all mostly U.S. lawyers. We are in the business of litigation. We need to come up with a better way to sell our business, because I do want to have cases in the U.S. representing Korean clients. If I advise Korean clients to steer away from U.S. jurisdiction by agreeing to arbitration agreement all the time, and they will stay away from ICR, or SEAC and HKIC is better than, or even ICC is better than AAA or JAMS, it's my business. So what I want to do is to advise the clients not to steer away from U.S. litigation, but to advise them that sometimes, because you're having your expansive discovery, it could be good for your client. You could actually be able to prosecute a case where you would not have otherwise in other jurisdictions. So a question that I want to share with all of us is, how can we change the U.S. discovery system such that it's not so expensive and so wasteful? Because a lot of it, we admit, is very wasteful. And we like to win on, not on the merits, but on litigation discovery strategy a lot of times. And we have the statistics in Glenn's research. 98% of the federal court cases settle as opposed to go to trial. So we know if you advise a client, you endure this case enough, go past discovery, there is a chance for you to settle on a favorable terms, more likely than in other jurisdictions. So that's something that just came up in my mind. I just want to throw out. Second thing I want to also share is that I think a lot of Korean companies, because they're so tax savvy, they already are introducing into their corporate system a very savvy document retention system. I want to call it retention system, because we know we print much less. There's no paper evidence anymore, right? It's all ESI discovery. But servers also cost a lot of money, and they generate a lot of heat. And you've seen news that we have to now create servers in the bottom ocean bottoms, right? Because they generate heat. So the amount of information that we store electronically could also be very costly to the environment, and I think companies are picking up on that. So having a very short span, 3 months document policy, retention policy, I think it's becoming more prevalent in Korea. It's not surprising actually. And we advise, as in-house counsel, advise our corporate clients, not because we want to dodge discovery obligation, but because it's more efficient and it's risk averse. But it's also it's sound policy not to retain everything in your corporate record unless it's require under the law to retain accounting records for 10 years, which is the case in Korea. Going back to how do you use contracts to avoid having to undergo huge litigation risks that you should not have to endure otherwise. I do advise clients to agree to arbitration agreements and make sure. Sometimes I've seen in the document, in the contracts where you say we specifically agree not to use U.S. style discovery. I don't know if you've come across that kind of language. I've seen a lot of Korean contracts actually have that one sentence in there, but you can't really deviate what's written in this procedure, right? But companies have tried to do that, and in some arbitration cases, that actually did work. Where the tribunal thought that the parties agreed to this specific language means that you want to do less than what would typically required, for example, in the reference schedule or stern schedule, right? So.
Okay, well, I wanted to leave a little time for questions, so maybe I'll ask kind of the final big theme topic, which is bridging the gap. We've talked, let's go ahead and talk about ways we can bridge it. I mean, we already have. But again, just to wrap it all up, and let's start with Chin Hee. As former inside counsel, now outside counsel, what are some key concepts or practices to discuss with Korean companies? Because again, it seems like the audience here are mostly outside US-based counsel. What are some key things you would recommend that they discuss with Korean clients?
So if you have a long-term relationship with a client, obviously what you're going to discuss is going to be different. If you constantly advise about litigation risk, for example, discrimination is one thing that Korean clients are not so. I mean, look at it. The Korean society is one of the most homogenous societies in the world, right? So discrimination is not a big topic unless it's sexual discrimination. We have seen some discrimination against women being cases that are discussed. But racial discrimination, age discrimination, it's not something that Koreans are used to, Korean management is used to. Something raising issues like cases in the US that could be of interest to your client. I think it's a good way to apprise your client of, hey, we could be mitigating your future risks. Another thing, litigation hope is so important, not because just because it's not practiced here. But as soon as you have a case or a potential case, first thing I will tell you is to disseminate this case to everybody that is concerned. Another thing is advising the client to be able to see litigation as a tool. You don't want to say that in the judicial process you can actually abuse it. But I do advise Korean clients that being hauled into litigation is not the end of the world, because a lot of my Korean clients are very averse and very scared of just being in litigation, not just in the US, but everywhere. They're very, and they take on compromises that they shouldn't just to avoid litigation. But I think what I would like to advise the clients is it's okay to be sued. You can still manage it, but it takes a lot of cost than it's in the US.
Yeah, I don't know so much about bridging the gap beyond what Jin has said, but I do think, contracts are key, and it's not just the obvious, arbitration provisions, but even just choice of forum, which is standard, I think in most contracts, but in the U.S., just being aware of how different the risk is depending on venue. I mean, a lot of times venue almost determines everything. And it even comes down to where do you select your corporate headquarters in the U.S., because that's often, obviously, where you're going to be sued. There's an organization called the American Tort Reform Association. Every year they put out a list of what they call judicial hellholes in the U.S. And there are places where, juries are just prone to hand out really what they call nuclear verdicts. We had one in Georgia last year, $1.7 billion, not million, billion dollars. And so being aware of where those are, if you're headquartered in the right place and you get a demand letter, you may be, notwithstanding the reticence of, say, a Korean company to be involved in litigation. They may want to go on offense, file an action for declaratory relief, and that way they get to pick the venue. Because venue, again, is often almost outcome determinative. Even within, let's say, the Atlanta metro area where we are, you'd much rather be, let's say, in Gwinnett probably than DeKalb County, you know, as a defendant. So things like that are really critical.
I'll just add a small thing before passing the mic to Samantha. But from an employment perspective, we've been focusing on, federal laws. But, there are employment laws at the state and local level. So no matter how big the company is, it's really important that they retain local counsel experience in that state, in the state, the jurisdiction where the company is based. Because there's so many levels of exposure, not just on the federal level, especially when it regards their personnel. And I found that probably personnel is like one of the number one risk for foreign companies. They're not used to the American style of litigiousness. It's kind of a surprise to them. So just making sure that they have really solid local counsel that can also advise them on all of these issues would be important.
I'm just going to touch really briefly back on the contracts component because I think this is an important nuance. I think Jimmy was absolutely right that the approach to contracting, at least in my experience between Korean companies and U.S. companies, is very, very similar. But maybe how we look at the contract differs slightly. There are a few nuances there, at least in my experience, and please forgive the generalization, but in working with Korean clients, often if you're in a situation where there's a potential business dispute, the first question that your internal clients, in my case, or your clients might ask you is, hey, how do we work through this? How do we resolve it? What's the path forward? The first question that your U.S. companies are going to ask is, what does the contract say? So generally speaking, there's just a little bit of a nuance there on how we look at things differently. So one thing to advise your clients on is making sure that they're strictly following the terms and conditions of the contracts that they've agreed to, because the concept of waiver, particularly when you're dealing with big transactions, construction matters, things of that nature, is significant. The other item that I just want to mention, which I do think is important, and I'm going to put my compliance hat on for just a second. Keep in mind that if you're doing business in the United States, doing the bare minimum of what the law requires is not always going to be sufficient. So reminding your clients that best practices exist for a reason. So maybe, not just focus on what the law actually requires, but talk to your local counsel. Make sure that you're, communicating with U.S.-based attorneys to understand what are best practices. Just again, with an example on that, the difference between at-will employment and best practices. What should you actually be doing, not just doing what the law requires, I think is an important thing to keep in mind.
Any questions? Questions or comments? Yes. And please introduce yourself.
Okay. My name is Yoshika Katori from Japan, the independent arbitral mediator. And naturally, I would like to ask regarding the ADR strategy for your session. First of all, thank you very much. Excellent session. And then, even during the litigation, US litigation, even without the arbitration clause, you can try like a mediation. Maybe two kinds, like a court-managed mediation or ad hoc mediation, like whatever super like a mediator or something. And I have experienced such ad hoc mediation in California court litigation during the California litigation. After obtaining the first instance court's judgment, then filed appeal. But before appeal, we tried the kind of ad hoc mediation that was successful. So my question is yes. For what kind of the nature of the litigation or what timing you should think about such, trying the mediation, as because that could be minimizing such, huge damages. But still, the winning party should stuck into the such judgment, and then they prefer like such huge compensation. So, in what case and what timing, and which one, the court-managed type of the mediation or ad hoc mediation. So comparing such kind of advantage or disadvantage or something, I'd like to have your advice.
That's a great question.
That's a great question, because mediation is something we probably should have talked about in the main section, because it's such a ubiquitous key feature of dispute resolution in the U.S. I mean, really, most cases, and it's a fair generalization, most cases you're going to have a mediation at some point, whether it's court mandated or not, or the parties just agree to it. And in terms of timing, I would say, we talked about contracts. It's a good idea to have a, good faith conciliation mediation provision in your contracts, so that before you ever get to a litigation arbitration, it's built in as a contractual obligation to talk. And so that's one way to nip it in the bud. In terms of which is better, court mandated or ad hoc, I don't think there's a general rule on that. One thing I like about court-mandated mediation is neither party is losing face. By going into mediation, there's no sign of weakness. Hey, let's try to mediate this. But mediation, I think, is one of the more successful features of dispute resolution in the U.S. And it kind of goes hand in hand with discovery, because we hear all these awful things about discovery, but one of the positive things about discovery is before you ever have to go to a trial, you have a general sense of what your strengths and weaknesses are in the case. And that's the idea behind it. And so you go into a mediation, pretty well educated, and able to educate the client on the risks. And mediators, it's a profession in the U.S. They're professional mediators that are very good at it. And you really can't understand dispute resolution in the U.S. without having to understand mediation. And it happens at all phases of the case. It can happen beforehand. It can happen after you've already lost and you're up on appeal. I've got one of those right now. It just happens throughout. But I would say most often it typically happens after you've already had some discovery and the parties have some idea of what their respective is.
You also asked about types of cases. Do you feel like there's a certain money number, or is it commercial disputes or employment? Or
It really, in every type of litigation that I'm familiar with in the U.S., mediation is a key feature. Tort cases, contract cases, yeah.
I don't know if I should be ashamed to say this or proud to say this. I've done in my short career more than 100 mediations. At one point, I was managing 80 cases for one client, and each of those 80 cases had at least 1 or 2 sessions of mediation. Mediation is a very key feature of U.S. litigation. It is essential, ubiquitous, and it does settle a lot of cases. Working for a Korean client was not easy to do, and I think it goes back to the structure of decision making. So in a lot of Korean companies, the legal team assists the business branch managing the case. So unlike a U.S. corporation, when you have a chief legal officer who will be able to call, okay, let's settle at what amount, and let's just do it. Your client, or your Korean client you're speaking to every day on a daily basis is a perhaps English-speaking legal officer or somebody with a law degree in the legal team. But that legal team person reports to a different business section that handles the type of business that you're handling. And that person does not necessarily understand litigation or mediation. And that decision to dispense with a certain settlement has to come from that person. So working through a mediation session, preparing for mediation, making a decision at the mediation is extremely more difficult with Korean clients. But based on my experience, the earlier you mediate, the better. Because once you have expended so much money on discovery, parties are tired emotionally, and also, unless you know for sure that you have a losing case and you're being called until the last minute to pay a higher amount for settlement, I would advise my Korean clients to consider mediation at all times. In U.S. litigation, one good thing about it is that we know 98% of them should settle before trial. And so I think it gives them the comfort of knowing that there is settlement ahead. I don't know if this answers your question.
Any other questions or comments? Yes.
I don't need the mic, I'll just project. I litigate in a practice area that is infamous for the speed and depth of its discovery, where I'll need information and documents in weeks or sometimes days. So I would love some pointers or advice on how we sort of ease the sting of that and smooth that process out with our foreign clients, because I know that when they're not accustomed to any discovery, suddenly we need everything right now. It's very unwelcome. So what advice do you have to set that sort of up?
I think this probably goes for any company, but just to generalize, I would say, make sure that you're setting expectations with your client. Just really help them understand not only what you need from them, but why you need it and when you need it by. I think, at least just dealing, being in-house, you get a lot of requests, particularly when you're in a situation where you have, you're acting in anticipation of litigation, you're gonna have a lot of people to talk to. Help, try to take advantage of your in-house counsel that you have at your internal clients, and they can help disseminate those requests to all of the people who may have the information. Because I think what we talked about earlier, not only with respect to decision-making, is a little bit more decentralized, and there's more people involved. It's the same thing with the information that you're gonna need. They're gonna have to go to a lot of different places to get it. So set those expectations early, help them understand what you need, when you need it by, and specifically why you need it. I think it's gonna be crucial.
It's lunchtime. I'm not gonna let anyone sit here and be hungry. Thank you so much for joining us.